3, 2, 1, start. Thus, the charges leveled against the petitioner are absolutely vague, and the respondents have proceeded in a biased manner to victimize the petitioner, and such infirmities malign the charge sheet itself and renders it to be unsustainable in law. Stop para. A perusal of the inquiry report reveals that in the backdrop of the observations to the effect that no prior permission was obtained for the petitioner for attending the said presentation of IEEMA and that the airfare was allegedly borne by SML, the inquiry officer, by implication, came to a conclusion that the action of the petitioner was a kind of borrowing money from a private organization. Stop. Furthermore, on the basis of a statement of PW4 that the petitioner did not stay at the inspection bungalow at New Delhi on 16th April, 2008 and 17th April, 2008, the inquiry officer was of the opinion that the petitioner availed hospitality of SML. Stop. Such conclusion as arrived at is based upon surmises and conjectures. Stop para. The word integrity is synonymous with probity, purity, uprightness, rectitude, sinlessness, and sincerity. Stop. In the instant case, there is no evidence on record to allege that the petitioner's integrity was questionable, more so when the petitioner was not found to have committed any act of misconduct pertaining Regulation 61 within bracket B and Regulation 61 within bracket E of the said service regulations. Stop. Furthermore, the prosecution witness number 4, namely Sri Subroto Kumar Das, additional chief engineer, in course of his cross-examination stated that I can depose that the CO never lacking in his sincerity and integrity towards his work. Stop para. From the inquiry report, it is explicit that the inquiry officer had merely recorded his ipsi dixit that the petitioner has committed misconduct specified under Regulations 61 within bracket E and 61 within bracket P. Stop. A perusal of the inquiry report reveals that the inquiry officer did not accept the charge of violation of Regulation 61 within bracket B and Regulation 61 within bracket D, but held that the petitioner constituted gross misconduct, breach of discipline, and negligence of allotted duties in terms of Regulation 61 within bracket E and Regulation 61 within bracket P. Stop para. For proper appreciation, Regulation 38, Regulations 40 within bracket 2, 61 within bracket B, 61 within bracket D, 61 within bracket E and 61 within bracket P are quoted below. Semicolon para. 38. All employees of the board shall at all times maintain absolute integrity and devotion to duty. Stop para. 40 within bracket 2. No employee shall, save in the ordinary course of business with a bank, borrow money from or otherwise place himself under pecuniary obligation to any person with whom he is likely to have official dealings, nor shall he permit any member of his family, except with the previous sanction of the board, to enter into any such transactions. Stop para. 61 within bracket B, breach of administrative rules, orders and circulars, semicolon. 61 within bracket D, neglect of allotted work and careless or inefficient performance of duty, semicolon. 61 within bracket E, causing loss to the board by any act of the employee or by the failure on the part of the employee to act in the manner he should have done, semicolon. 61 within bracket P, any other acts which are commonly and generally known or understood to be against the canons of good behavior and discipline. Stop para. It is surprising that though the petitioner was not found guilty of having violated any administrative rules, order and circulars and of any neglect of allotted work and carelessness or insufficient performance of duty, the inquiry officer arrived at a finding that the petitioner has committed acts against the canons of good behavior and discipline. Stop. Such finding is absolutely unfounded and perverse. Stop. The inquiry officer has not specified the acts by which the petitioner has acted against the canons and good behavior and discipline. Stop. It is also not understood as to how the inquiry officer could have arrived at a finding to the effect that the petitioner caused loss to the WBACDCL, though the allegation against the petitioner was that he has violated regulation 40 within bracket 2. Stop para. The inquiry officer has proceeded on an erroneous premise to the effect that the petitioner has borrowed money from SML. Stop. Payment of the airfare was made by the petitioner and not by SML on 28 April 2008, and that only the fact that the petitioner approached SML to book the tickets through its travel agency does not establish that the petitioner exposed himself to a pecuniary obligation, and the nexus and linkage sought to be drawn by the inquiry officer among the petitioner and SML is absolutely perverse. Stop.